Steve, big morning for you.
Yes, ma'am. We had a big time in the U.S. Court of Appeals for the D.C. Circuit in the Heller 2 case.
Yep, and you were saying the court was packed, and I can understand why. A lot at stake here. In this particular case, you're challenging really restrictive gun laws that Mayor Fenty and his police chief are putting in place despite the ruling in the first Heller case. So how do you think it went?
It went very well, and I must say I opened my argument by saying the following, that in response to the Supreme Court's decision in Heller, the District of Columbia enacted the most radically restrictive gun laws, restrictions on firearm possession of any jurisdiction in the U.S., and they did it with the misconception that the Second Amendment does not protect a fundamental right, and therefore some kind of only a reasonableness standard applies, where they can basically get away with saying anything in the committee report and then expect the court to uphold it.
Yeah, I mean, it's real. When you look at what they're talking about, one of the issues is these registration requirements. We're talking about a laundry list. I mean, everything from a payment of $125. One of my favorite is that one that you pointed out previously about, 1 hour of firearm training, but there's no range you can go to in D.C.
That's right, and they make you take a handgun course. You have to go to Virginia or Maryland to do that because there's no ranges in D.C. Just to possess a bolt-action .22 rifle, you have to take a handgun training course. That's all that's recognized by D.C.
And the other case, it was interesting. Along with Mr. Heller, there was 3 other plaintiffs. And one of them, I hope I say his name, Absalom Jordan.
Yeah.
He applied to register an Armalite AR 180 caliber rifle
That's
to
right.
use for personal protection.
Yes.
And they said, you know what, sir? That's defined as an assault weapon, and no way.
Right. Assault weapon means anything they want it to mean. For example, their definitions of assault weapons has a long, long list, and then the last one on the list is any firearm that the chief of police finds is against the public interest.
Yeah, so he makes the definition. They set the standards.
Well, and what we focused on was the AR-15 type rifle.
Because you're talking about they're used in competition, they're used at national matches, hunting, law enforcement, you name it.
Right, civilian marksmanship program. We put on evidence based on ATF data that there's been over 2 million AR-15 type rifles manufactured for civilian ownership. And I have to say it's not in the record, but I think the figure might actually be closer to 3 million. But it meets the test in Heller that if a firearm is of a type that's in common use by law-abiding people for lawful purposes, that's what the Second Amendment guarantees. Mm-hmm. And it generally, at the higher level of generality, guarantees possession of rifles, handguns, and shotguns. And the AR-15 is simply one model of a semi-automatic rifle that many Americans prefer.
Mm-hmm. I mean, you never know how a judge or a judge panel, you're talking about 3 judges on this panel, correct?
Right. Judge Ginsburg, who's been there for many years, a very well-respected judge who was considered for the Supreme Court at one time, and Judge Kavanaugh, who's a younger judge. He's been there, I think, only 3 or 4 years or so, but he asked very probing questions. And Judge Henderson, she actually dissented in the Parker case, but of course the Supreme Court resolved that case in the D.C. versus Heller case adversely to her dissenting view, and she's bound to apply the Heller decision. So although she did not ask questions to me, there were many, many questions asked by Judge Ginsburg and Judge Kavanaugh to both sides, myself and the D.C. Solicitor General Todd Kilm, and I thought that the questions reflected that the judges were very, very well prepared for the argument.
And did any that stand out in your mind, either that they asked of you or of D.C.?
One thing that was asked of me, I argued, of course, that D.C.'s registration system is the outlier. There's no other city that has such a, or state that has such a, other than maybe Chicago, onerous requirements. Hawaii does require registration of all firearms, but there's no expiration and re-registration aspect to it. So I was able to bring that out, that, yeah, there may be some selected cities also that have either registration or so-called assault weapon bans, but In the case of Ohio, for example, I myself have litigated those assault weapon bans and had one of them declared unconstitutionally vague, and we now have preemption in that state. So D.C. can cite a handful of other places that has bad laws, but either they're invalid or their existence doesn't mean they're consistent with the Second Amendment.
And I'm sure D.C.'s argument is what it was always been, and that is that, this is all about public safety, what's good for the communities. Is that what you heard today?
Well, yeah, we're for public safety, and we're for what's
Absolutely.
good for the community, and of course,
and it's called self-defense.
What means is respect for Bill of Rights guarantees and the ability of law-abiding people to protect themselves. So, yeah, D.C. uses that rhetoric, but it uses it in a way to try to restrict the rights of citizens.
And as you said, it's a right to self-defense. But, I was going to say, a judge on that panel, as you pointed out, Heller talks about, that the sorts of weapons protected were those in common use at the time. And, I would think these judges would have to look at, would likely look at D.C. as just thumbing their nose
right
at the high court.
One comment that I thought was very telling from Judge Ginsburg was on historical precedent. D.C. had cited in its briefs about long-standing British precedent like Catholics could not own a gun. Under the English statute of 1689, only Protestants could. And you seem to chuckle about that, like, are you telling me that's a precedent for what we have now, or that there were loyalty oaths required to own guns during our revolution? Well, that was in a wartime. We were not only disarming Tories and British, we were killing them. They were trying to kill us as well. So, to try to apply that, in fact, Judge Ginsburg asked whether under district law, is there a loyalty oath required to own a gun?
Yeah.
So, and I got to point out how you want to talk about British registration precedent. Well, in 1660, Charles II took power, and he required gunsmiths to report gun sales to the Crown. 2 years later, they passed a statute saying that they could do searches and seizures for guns for any people who might not be loyal to the Crown. And these are the kinds of restrictions that the Second Amendment was determined to try to prevent, not to allow these things to go on. So D.C.'s argument is that anything adverse that's happened to people's rights in history is proof that it's okay to do it.
Oh, okay. So then the gun ban in England.
Right. They restricted the rights of people in England, so it's okay to do that here because that's the heritage we inherited.
Well, and if Mayor Fenty had his way, that's what he wants to do, and that's why he's making these outrageous restrictions that really do. I mean, they violate everything the High Court said.
That's right. I mean, one argument that they made that Heller itself rejected was, let me back up. When Heller was argued, they said, well, you don't need a handgun to defend yourself. You could use a rifle or a shotgun. And now they're basically saying, well, you can use a handgun. You don't need a rifle.
Yeah, that's true. I remember that now. That's exactly right. Yep.
Yeah,
so,
and that doesn't go over too well because there's a lot of First Amendment law saying that you can't ban free speech in one place just because you could exercise that same free speech in some other place.
And, you really have to hand it to Mr. Heller. I mean, from the very start, and he has not given up on this fight one iota. He keeps fighting, and he keeps saying it's not just for him. It's for all law-abiding citizens. And, he doesn't like the fact you can regulate, you can restrict, you can put a price on our constitutional rights. Did he say anything to you after the court today?
Well, we had a meeting. He attended, and also William Carter, another one of our plaintiffs, and I think they were very pleased with the way the argument went. William Carter had actually bought a AR-15 type rifle before D.C. banned it, and he paid for it even. And then when it came time to complete the registration, this law had been passed, and he could not take possession of it. Another one of our plaintiffs is named Mark Snyder. All he wanted to buy was a biathlon type single-shot .22 rifle. And he's got to jump through all these hoops, pay these fees. And then Absalom Jordan, he's been supporting Second Amendment rights in the D.C. community since the 1970s. He's a great friend and a real active supporter of the Second Amendment. We were very glad to have him in on the case.
Yeah, and I'll look forward to talking to them all. But so how long do we have to wait for this court to come down with a decision, or what happens next?
Well, you never know.
Yeah.
You just never know, so I don't want to. I never predict when a decision is going to be made or what the outcome is going to be. I feel good about the way the argument went. I thought the judges were treated both sides very fairly, and so we're looking forward to finding out what the opinion will be. It'll be most likely it'll be several months.
Oh my gosh. Well, it's sure. I mean, well, everyone is watching, and it will be interesting to see what happens, and let's hope it all goes well in the end.
Let's hope that constitutional rights are upheld. That's right.
That's right. That's for sure. All righty. Thanks so much, Steve. Thanks for all you do always.
Thank you, Jenny. You take care. Bye.
All righty.